matters as well. We practice in federal courts, which is what this webinar is about today. We will be talking about litigating claims in federal court, how to file claims, and what the process is. If we could go to the slide that specifically says all the topics for today's webinar. So as the topics list, we're going to talk about how to file employment complaints in federal court. What are the requirements to file in federal court? Which Texas federal court to file your employment complaints? And what type of employment law claims can be filed? And what happens after filing a complaint? The procedural process of a federal court action. We'll talk about discovery. What is that? What happens in Texas federal courts as far as discovery? And we'll also talk about how a jury trial works in federal courts in Texas. So we have a number of topics here to discuss today. I'm going to start out and discussing these initial topics, and then after I'm done, I'll turn it over to my colleagues. Okay, so the first slide here we're going to talk about is we can switch to the next slide. How to file an employment complaint in federal court. Filing in federal court is a lawsuit. So, you hear the term lawsuit, and that's what it is. You're filing in court. You're filing in a court where there's a judge that's assigned to the case. So when we say initial complaint, you're filing a lawsuit. To file a lawsuit or to file a complaint, you must have standing. What does that mean? You must be able to bring a lawsuit. That's what standing means. You must be a person in the employment law context that has suffered some kind of harm through their employer in the employment law context. Standing may mean something different if you're not bringing employment law claims, but generally you must show that you've suffered some sort of harm to bring a complaint in federal court. There are other requirements specifically for the employment law context that we'll get to here in a second, as far as exhausting your administrative remedies. But first, we'll go over, well, what are the laws or statutes that provide you with that cause of action that's standing to bring these employment law claims. And on our screen here, we have several of the statutes that employees could use. One of the main ones is Title VII of the Civil Rights Act of 1964. This law protects against discrimination in the employment context. Specifically, it protects against discrimination on a number of protected bases. These protected bases are race, sex, national origin, religion, color. And this means that employers cannot treat an employee differently because of these protected bases. In addition to those protected bases, there's also retaliation, meaning that an employer cannot treat somebody differently because they've complained about race, sex, national origin, religion, or color discrimination, or even other types of discrimination. There's also the Americans with Disabilities Act and the Rehabilitation Act. Those acts protect against disability discrimination, specifically individuals that have disabilities in the workplace or disabilities, and they're treated differently by their employers in the workplace. These acts protect against discrimination against disability. The main difference between the Americans with Disabilities Act and the Rehabilitation Act is that the Rehabilitation Act specifically applies to federal government workers, but they do intertwine and overlap. But the ADA, the Americans with the Disabilities Act, applies to private sector workers, and the Rehabilitation Act applies to the federal government workers. We have the Age Discrimination in Employment Act, which protects workers over the age of 40. Those are workers that are discriminated against based on their age. And to qualify, you have to be over the age of 40. And then we also have the Genetic Information Non-Discrimination Act. This act protects against genetic information discrimination. Protects against you being treated differently because of your genetic information. These acts also employ a hostile work environment analysis, meaning if you feel that you've been treated differently or subject to a hostile work environment over a period of time, you could use these acts to go file in federal court. But these are the main laws that employees could use to file in federal court. There may be others, local state laws that are counterpart to these, but these are the main laws that employees could use to file in federal court. Like I said, you have to also prove that you have some sort of injury or remedy. Those remedies could be if you've lost your job, well, your remedy would be getting your job back and associated back pay. Or if you've been demoted or suspended, those are remedies. Remedies could also include pain and suffering. If you're subject to a hostile work environment and that's caused you pain and suffering, if your supervisor has harassed you, that could cause you pain and suffering, and those are remedies as well in the court context. There are other remedies that could be associated as far as lost pay, lost benefits, change of job duties, but you have to prove that you have some remedy as well. We're talking about the federal court context here. However, certain employees do have the ability to file in state court. In Texas, there are state courts that do adjudicate claims of discrimination. That depends on your employer, whether you brought the lawsuit under a state equivalent of the Title VII of the Civil Rights Act. But if you've filed a lawsuit or brought a claim pursuant to a federal law, such as the Americans with Disabilities Act or the Title VII of the Civil Rights Act, you do have the option to go to federal court. And then we have here as well arbitration. The reason we included this note in this presentation is because several employers will include what they call mandatory arbitration clauses. Those are clauses that employers include to mandate that their employees go to arbitration over any employment dispute. And this would, in the employer's opinion, prevent an employee from filing a lawsuit over discrimination claims or over any dispute in employment, and instead they have to go to an arbitration. If you have an agreement that you've signed or been offered regarding that, I urge you to, understand that that's been in your agreement and to consult an attorney, because sometimes those clauses, even though they appear mandatory, can be challenged in the employment law context. But arbitration is a different process than federal court, and if that does apply, then that would prevent you from going to federal court and filing a claim. You would instead have to go through the arbitration process, which functions like an administrative hearing process. But just be aware if you do have an arbitration clause in your employment agreement where you're mandated by your employer to go to arbitration. As far as the next slide here, requirements to file an employment complaint in federal court. So I mentioned just a little bit ago about one of the other requirements for employment law claims, which is administrative exhaustion. What that means is for employees that want to bring an employment law claim, they first must file the claim with an administrative agency. An administrative agency specifically like the EEOC, the Equal Employment Opportunity Commission. The Equal Employment Opportunity Commission is an administrative agency that reviews, investigates, and decides whether discrimination has occurred. Or if it cannot decide, will allow you to go to court. But employment law claims must go through an administrative agency such as the EEOC. There are state entities, state agencies that also investigate claims, such as the Texas Workforce Commission, where a Texas employees could go to the Texas Workforce Commission and they will investigate claims as well. But these claims must go through the EEOC process, so there could be an investigation of the claims. And the goal is for the EEOC to resolve your claim so you don't have to go to court. But if you do not file with the EEOC or the Texas Workforce Commission prior to filing in court, your complaint may be dismissed. There may be certain employment law claims that you don't have to go through the EEOC process, but for the majority of them, you do have to go through the administrative exhaustion process. And even more broadly, you need to make sure that all the claims you are bringing through the EEOC process or in your complaint had gone through the EEOC process. Of course, there's exceptions to this. If you get fired after you filed in federal court, you don't have to go back and go to the EEOC process. You should be able to amend your complaint to include that additional claim. But any claim that you've had that you could have brought to the EEOC, you should have brought, or you may face dismissal. And then, like I said, the EEOC will issue a notice of right to sue regarding you filing in federal court. Jurisdiction. There must be subject matter jurisdiction and personal jurisdiction. That means that the courts have jurisdiction over the subject matter of your claims, such as the employment law claims, and that you're filing in the appropriate court. Such as if you're a Texas resident or in a Texas company, that the Texas federal courts have jurisdiction over your claims. If you are filing claims that perhaps do not fall within the Texas federal courts, so for example, there are Equal Pay Act claims that may not fall within the jurisdiction of Texas federal courts, even though they're employment related. Depending on the type of employee you are, you may have to file those claims in a different court, such as the Court of Federal Claims. The jurisdiction sometimes is fact specific, but in general, if you have brought a Title VII claim based on discrimination and you're a Texas resident, the Texas courts should have jurisdiction over your claims, and you've worked for a Texas employer. Similar to jurisdiction is venue. Venue is where the claims are most convenient for the parties and most convenient for the witnesses. And venue is, well, if you are in the Western District of Texas, meaning if you're in the Western District of Texas and there's a list of counties that are in the Western District, that's where those claims should be brought. But if you're in, for example, the Southern District, perhaps in the Houston area, then those claims should be brought in the Houston area in the Southern District. So that's really means where physically you are as far as venue is concerned. But you must file in the appropriate venue. Now, with the venue and jurisdiction, if you have not filed in the appropriate venue or the appropriate jurisdiction, then you may receive from the defendant a motion to dismiss or a request to change venue, and then you would be able to oppose that. I will say for venue, that would be usually with venue, motions regarding venue, the courts won't dismiss a case because a case is not in the proper venue. Rather, they would transfer the case to the proper venue. As far as other requirements to file, you must be able to serve your complaint. And we'll talk about this, what steps to take after you file your complaint. But just touch upon it briefly here, you have to be able to serve your complaint after you file. You need to serve it on the registered agent for the defendant or the designee for the defendant. There are different requirements for the type of defendant you've sued. If you're with the federal government, you must file a complaint and serve a complaint upon the Attorney General, the U.S. Attorney, and then the designee for the federal government agency. If you're with a corporate defendant, a company, you must serve on the registered agent. But you must complete service within the 90 days of when you file a complaint, for most type of complaints at least, and for the case to get started. And we'll talk more about that as far as steps to take after you file. But another requirement you must do is when you file, there is a filing fee. If you're filing in a federal court, the fee is generally about $400 of filing a complaint in federal court. And that the court does require you pay that. You file, by the way, online. You can file on a site called pacer.gov where you file your complaint. And you submit it on pacer.gov and you pay the filing fee. However, you could, I think most courts or some courts at least will accept a filing in person if you go to the clerk's office, or at least you could go to the clerk's office of that courthouse and they will help you file online. But the federal court cases are, the dockets are online on pacer.gov, and those are public unless you request it not to be public. So if you have a pending federal court action, you may be able to look up your pending federal court action by just searching your name online and finding it on Pacer. That is how the federal dockets have operated for several years now. The other requirements to have in your complaint are a jury demand or a prayer for relief. So for a jury demand, it is your option. That means you could request to have a jury decide your case. But if you don't request it, then a judge will decide your case. But that's something you need to, if you want a jury, you do need to include in your complaint that you would like to have a jury. A prayer for relief, that just means you need to spell out the items that you believe you need for relief of your complaint. I gave the example earlier, if you were terminated from your job, then you would want to include, well, in relief, I would want my job back, I want my lost wages. If you've suffered pain and suffering, you would want to include that as well. We also talk about here the duty to mitigate in settlement negotiations. So the duty to mitigate is a term of art, which essentially means that you have you are required as an employee to mitigate your damages. If you've suffered, if you've lost your job and you've lost wages, you are required to attempt to try to find another job to mitigate those lost wages damages. You also should engage in settlement negotiations, and the courts will require or request that you engage with the other party in settlement negotiations. Prior to filing a lawsuit, you could engage in settlement negotiations with the company you're suing or the employer you're suing. And it is always beneficial to tell the court after you file, well, hey, I've tried to resolve this complaint. I've reached out to my employer to try to resolve it. I mentioned the notice of right to sue earlier. The notice of right to sue, again, is a notice the EEOC will issue you saying you must file your lawsuit within a certain time frame of you completing the EEOC process. This is, in almost all cases, a 90-day time frame. And the reason I'm bringing this back up is because during that 90-day time frame between when the EEOC process ends and when you can file your lawsuit, that's an opportunity to try to resolve your case through settlement negotiations. And it's also to always keep in mind that you have that duty to mitigate your damages during that 90-day process as well. And to continue looking for jobs if you lost your job, if you suffer pain and suffering, to seek healthcare providers for medical treatment, you do have a duty to mitigate your damages. But these are a general overview of the requirements that you should include in your complaint and what you'd have to do before you file a complaint to ensure that your complaint could proceed in the federal court process. I will now turn it over to my colleague, managing partner Sean Timmons, to go over which court to file in your complaint and other processes.
Thank you, Mike. Thank you for the introduction and presentation so far. We're going to talk now about which federal court is appropriate to move forward with your complaint. There's 4 districts in Texas. Texas is a big state. Now, most states are divided into 1 or 2 districts. Like, for example, Kansas is just the Federal District Court of Kansas. The entire state for federal court is just 1 district court. Texas, however, being a large state with 30 million residents, is divided into 4 categories: Northern, Eastern, Western, and Southern. Thankfully, I'm licensed in all 4 federal district courts across the state, and frequently appear in each of them around the state quite often. Thankfully, logistically, Southwest Airlines in Houston gets me to all these spots pretty quickly, and we can appear just about anywhere. I spent a lot of time in Dallas. It's a quick flight from Houston. The Northern District Dallas, Fort Worth, Lubbock, Amarillo. The map is not necessarily geographically accurate. Like Southern District of Texas includes Houston, for example. Houston's not really South Texas, but it's considered South Texas for the purposes of the federal court division of our courtrooms. So Houston covers Corpus Christi, Laredo, Brownsville. Brownsville is Cameron County. Laredo is Webb County. Houston is Harris County, and all the counties surrounding those areas would be the Southern District. Myself and Mike have actually tried several cases here in the Houston area in federal court downtown Houston, and it's quite an experience. Western District, we have several docketed trials pending in Austin, along with San Antonio, El Paso, Midland, Abilene. That's the general nature of the locations there. And Eastern, we've had several cases docketed, and we've been very close to getting the trial up in Sherman, Tyler, Plano, Beaumont, Texarkana, and other areas, the Eastern District of Texas. Now, the Eastern District is known nationally as the location for intellectual property disputes, so it's got a specialized niche of handling those. They're not necessarily the best for employment cases. The rest of the courts, they all generally have a large docket of employment cases. I did talk to some federal clerks recently at one of our conferences, and they mentioned employment cases seem to take up a large chunk of the docket when it comes to litigated disputes. So each court generally has significant familiarity with Title VII claims. Title VII claims are fact-specific, fact-dependent, so they often get litigated in federal court and resolved through the federal litigation process. Each district court is, represented by a judge who's appointed for life by the president, then approved by the Senate and confirmed. Each judge brings with them a judicial philosophy. Some judges have a judicial philosophy that's considered originalism or more conservative, such as Judge Hittner here in Houston. Other judges are more progressive, and they have more of a open philosophy of a living constitution. There's benefits and burdens to knowing the judge's judicial philosophy and picking your venue and where you want to file, because if you have the option to file in multiple spots, you may want to try to venue shop or forum shop when it comes to picking your chances of potentially getting a favorable judge. Which judge you get may ultimately be dispositive of whether your case is dismissed early or goes to trial on the merits, where you have an opportunity to obtain the best outcome possible. For example, we've had cases that we thought were factually relatively difficult, but we've had really good judges, and they've allowed the process to continue. And we've had cases that we thought were really strong, and judges were obnoxious, and we've had to go to the Fifth Circuit to go back to the court to get things restarted, because some judges are very strict about what they allow through the filters of their courtroom. Meaning, it's important to look at the background of a judge. Now, if you're a plaintiff, if you're suing your employer, you're generally considered in the phraseology of the little guy. You're by yourself, or you're with a small firm, or you're with a lawyer on your own. If you're going up against, say, IBM Corporation or Tesla or any major corporation, they're going to have armies of lawyers paying them $1,000 plus per hour, and you're going to be in there. The deck's going to be stacked against you. And the federal court system, in my personal opinion, is kind of clogged with cases between, say, for example, Microsoft suing Apple, where you have $1,500 an hour lawyers, 10 on each side, battle royal, Godzilla versus King Kong. And that clogs up the court system, and then your case is kind of left to take a number and wait, because it's not considered as a high priority, or the attorneys involved are not making it as much of a nuisance to the court to get it resolved. That's a very unfortunate predicament procedurally we are stuck with currently. The federal courts also have significant rules that require mandatory compliance, and they're much stricter about following the rules to the text of the documentation and the rules than, say, state courts, where there's elected judges who want to get reelected. State judges who are up for reelection will generally bend rules a little bit to be accommodative of the community, because they want public publicity, they want good rapport, they want to get reelected, they want to keep everybody in their good graces, and they also have many contributors to their campaigns appearing in their courtrooms. Federal judges are immune from that kind of process and that kind of thought consideration, and they are generally like a king of their own fiefdom, meaning they run their court as dictator, and they can set rules that are quite obnoxious and quite ridiculous, personally. And each federal judge seems to think, in my personal opinion, not every one of them, but a large number of them seem to act like the attorneys appearing in their courtroom only practice there and don't have any other obligations. So federal judges can be very difficult to deal with. If you're pro se on your own, it is almost insurmountable. It's a very, very difficult process to do it independently on your own. So it's highly advisable if you're going to appear in a federal court to have counsel with you if at all possible, because the federal system is much more complicated and difficult than the state court system that's ancillary to that process. Obviously, venue choice is potentially dispositive, because if you get a good judge who's favorable to plaintiffs, you might have a real strong traction in your case, and that increases your potential for evaluation of your settlement and potentially for favorable disposition. If you have a hostile judge, you may not get very far. So you have to do an analysis on where filing is proper, if filing in more than one spot is potentially available, and if so, what's the best place to file. Moving on to personal jurisdiction, you have to take into consideration, well, what are the facts of the suit? Where did they occur? And is there multiple spots? So, for example, sometimes there's overlapping jurisdiction. Sometimes you can file in more than one spot. But if generally the nucleus of operative facts occurred in one location, say you were a police officer in Houston and you were fired by the Houston Police Department, you probably have to sue in federal court in Houston, Texas. Taking that suit to San Antonio would get transferred out because there's not really a basis to bring that claim in that venue. That's a pretty straightforward example, but that's applicable across the board. You want to look at the corporation's headquarters, where they have their state of incorporation, their registered business address, where the events occurred. This gets complicated with remote work. If you're working in Texas and receiving a W-2 in Texas, you're generally considered a Texas employee, even if your company is based, say, in Seattle. If you get wrongfully terminated or discriminated against, and the events happen in Texas, you live in Texas, that's your domicile, that's your residence, Texas would have jurisdiction. Now, the employer being based in Seattle, you might be able to file in the state court there if that was to your advantage tactically. There is a strong move to try to file cases in California, which falls under the Ninth Circuit, because the Ninth Circuit is much more favorable to plaintiffs in employment contexts than the Fifth Circuit. The Fifth Circuit, based in New Orleans, is arguably the most conservative court in the country. Being a conservative court, they are very pro-employer. So you have a lot of obstacles in front of you when you're in the Fifth Circuit in the states of and the Fifth Circuit covers Texas, Mississippi, and Louisiana. So, for example, sexual harassment claims are very difficult to prove factually in the Fifth Circuit because they give a lot of deference to the employer. I don't agree with that personally, but that's the reality of the law as it exists in the Fifth Circuit. Additionally, some of the claims you may want to make, which may be personally egregious, may not rise to the level of actionable conduct within the framework of the Fifth Circuit, because the law in the Fifth Circuit, again, has a very conservative bent when it comes to applying the content of Title VII and other discrimination provisions. So we'll move on to the next slide. What types of claims can be filed in federal court? Now, there's an abundance of claims. This is just a short checklist because we're limited by time. We only have an hour to discuss today, so go through them quickly. Title VII of the Civil Rights Act was passed in 1964. There's also the Civil Rights Act in the 1860s, which is another claim that you can bring. America's ADA, America's Disabilities Act, which was passed in the early 1990s under President Bush. The Age Discrimination Employment Act, another 1960s era law. A relatively recent addition, Genetic Information Non-Discrimination Act. And additionally, recently in 2020, the court extended Title VII under the EEOC framework of Title VII to include sexual orientation. There was a lot of academic debate on whether sexual orientation claims were covered federally. States have started covering it within their state statutes. Texas was not one of those states. In 2020, the Supreme Court ruled that sexual orientation is a covered basis for discrimination, and now it's universally applicable throughout the country. All federal courts can hear sexual orientation discrimination claims if you're terminated or harmed at work based on your sexual orientation. So that's an expanding area of the law, and it's developing, but that's a relatively new development, especially in Texas, because Texas follows the federal minimum. Meaning, in the state of New York, for example, has a Human Rights Commission, has a Human Rights Statute, has additional protections. So does California. There's a lot of anti-discrimination provisions in the state of New York where you can't ask about salary information and you can't ask about criminal records history. Those protections don't exist in the state of Texas. Unfortunately, for better or worse, Texas follows the federal baseline minimum. We're just like in the minimum wage, still $7.25 in Texas, where almost every other state in the country has raised it. Texas follows the federal base. So we're in Texas, you're left with only federally applicable anti-discrimination provisions, generally speaking, when it comes to Title VII and other provisions. Hostile work environment claims. A hostile work environment is a situation where it's sufficiently, you're almost under duress based on the conditions at work. Every hostile work environment claim is fact specific and fact dependent. You can bring those claims in federal court in the state of Texas to adjudicate the merits of your situation and hopefully get it resolved. There's the Family Medical Leave Act, there's the Pregnancy and Discrimination Act, and the Pregnant Workers Fairness Act. There's been recent legislative developments on that, expanding the scope, allowing pregnant individuals to obtain relief in federal courts. There's the Fair Labor Standards Act, Uniform Services Employment Reemployment Rights Act. Now let me talk about that because that's my particular personal specialization. It's called USERRA. It's the Uniform Services Employment Reemployment Rights Act. That is the anti-discrimination provision that starts in World War II. Coming out of the Second World War, a lot of individuals returned back to their positions of employment and were put in the back of the line and demoted and not given the proper credit while they were gone. So Congress, in response, passed legislation saying, look, you need to return your employee back to where they were before they were drafted and mobilized and fought in war. Well, that has been expanded over the last 80 years. And in 2011, President Obama signed the 2011 Veterans Improvement Act, which expanded the scope of USERRA to include hostile work environment claims and other statutory provisions that's made USERRA arguably the strongest anti-discrimination statute on the books. So Title VII has obviously good language to protect against insidious discrimination. It's despicable and unlawful. However, there's a lot of provisions in the law that are protective of the employer. So, for example, an employer can inoculate itself from liability by offering a class on sexual harassment prevention. So if they tell everybody, look, don't engage in sexual harassment, but then you are a victim of it, you may not have a suit against your employer. You may only have a suit against the individual who conducted the actual harassment. And they may be judgment proof. They may not have any resources. So it may be a waste of your time. USERRA, though, is very paternalistic and is the opposite of Title VII. And the law, as written and applied, basically requires all deference to be given to the veteran. So the veteran gets a leg up on an application of the statute. And all deference being given to the veteran, all reasonable inferences have to be read in favor of the veteran, and the employer is almost on a defensive position immediately upon receipt of the lawsuit. They have to show affirmatively they complied with the rules or law, or they would have taken the action they took regardless of the status of the individual veteran. USERRA also has escalator principle requirements, meaning if you leave and come back, they can't restart your compensation back to where you were. They have to give you compensation equal to where you would have been upon return. A lot of nuanced, complicated provisions within USERRA. It's a very developing area of the law. Different circuits disagree on the application of what benefits are required to be provided and what are benefits that may not be required but should be provided in different circumstances. And there's a difference between labor law and employment law. So labor law generally involves unions and a contract, meaning a written agreement regarding the terms and conditions of your employment that the union negotiates. And if you join a union and you're part of that agreement, you may have to go through the union grievance resolution process first before you can go to federal court. You may have to exhaust your internal contractual remedies based on the terms of your collective bargaining agreement. And the collective bargaining agreements is under the umbrella of labor law. Employment law is broader and covers situations where there's no explicit employment agreement. Now, Texas, being an, quote, at-will employment state, does not require a contractual relationship for an employee-employer relationship other than the federal baseline minimum. So in Texas, if you wear, a blue shirt to work and they wanted you to wear a red shirt, they can probably terminate you if that's the legitimate only reason you're being fired. It's a right to work. So if they say everybody has to wear a blue shirt and you show up in red, they fire you, well, it's right to work. You're probably in a tough position unless you can show application was discriminatory and not fair or some other federal law would negate that. At will employment means it's at will so that each side can disengage from the employment relationship whenever they so choose. Federal law does kick in though and make it, you can't have discriminatory basis that's unlawful be the actual underlying justification. That would be in violation of the statute. So just keep in mind, if you are subject to an employment agreement or if you've negotiated a contract with your employer, You have to generally follow the terms and conditions of that agreement. Some of those provisions may not be applicable. Sometimes they'll have a choice of forum clause where it says you agree to mandatory arbitration in Jamaica or Finland or whatever. That may not be enforceable if it's not disclosed properly or it's not reasonable. The courts may set that aside. Non-compete agreements also are a big area of dispute. Some non-compete agreements are just unenforceable as written. They're unreasonable and they're a prohibited restraint on business relations and your ability to contract. Some are enforceable. Generally, the rule is the higher your contractual compensation, the more covenants not to compete and contractual restrictions on your ability to work for other competitors in the future could be limited. So if you're making $1 million a year and you agree never to work for a competitor, the courts may well enforce that. If you're working at Burger King and you agree never to work at any fast food competitors and they fire you, they can't sue you to stop you from working at McDonald's. That's just unreasonable. You know, going from one $10 an hour job to another, the courts are not going to look favorably on a covenant not to compete in that kind of compensation structure. Now, when it gets to senior executives, they will grant enforcement of the provisions, generally speaking, unless they're manifestly unreasonable or unconscionable. And that's all stuff for a later dispute. But that would fall under employment law, again, labor law. There's not a lot of unions in Texas. There are some like the railway, for example, certain electrical workers in Texas fall under unions. Government employees generally fall under unions. And there's collective bargaining agreements with, sometimes with teachers, fire departments, police officers. I will say, too, as a comment about federal court claims against municipalities and government entities are identified by the taxpayer. So if you're a firefighter or a police officer or a teacher and you're suing a government entity for discrimination, you're going to face an uphill battle because the government has no incentive to settle because they're not really on the hook for the liability. It's the taxpayer on the hook. So they're getting indemnified for their behavior by the taxpayer. And they'll often bring in law firms that basically rip off the taxpayer and just charge them whatever to file all kinds of motions and pleadings to drag things out to help you give up. Don't give up. Don't be afraid of that bullying tactic by government entities. But I've seen multiple municipalities utilize that. In fact, the most discriminatory employers generally are fire departments, police departments when it comes to USERRA and Title VII violations. It's quite tragic in many ways. Generally, corporate employers, because they have investors and they have SEC mandatory reporting compliance and they have other social media concerns, they generally at least try to follow the law. Many municipalities, though, feel above the law because they are the government themselves, and they flagrantly violate the law. For example, the Supreme Court admonished Texas for trying to keep a veteran out of state court under USERRA and ordered the state did settle that case. But the state of Texas was found to be egregiously violating USERRA and held accountable. Let's move on now to what happens after you file your complaint. Slide 8. Apologize, I could go on all day about war stories regarding litigation history with the federal courts and different claims. What happens after you file your lawsuit? So assuming you filed a Title VII claim or a USERRA claim or any of the statutes we've talked about so far, you have certain deadlines to file. So generally in Texas and across the federal system, there's statute of limitations of, say, 2 years for certain causes of action. Others have 4-year statute of limitations. Some even have 6 years. So if you're a debt collector, some jurisdictions allow 6 years to collect the debt. Well, if you're filing a discrimination claim, you generally only have 90 days. So the clock is ticking immediately upon receipt of that right to sue letter. So as soon as the EEOC administratively closes your claim and issues you that right to sue letter, you only have 90 days. So that means if you wait 91 days, regardless of the merits of your claim could be time barred permanently unless you have some legitimate excuse on why the statute of limitations should be extended under some, rarely utilized exceptions such as equitable tolling. Most of the time that won't work. And if you don't meet the 90-day threshold, you're just kind of, your claims will be barred by the time limitations. And courts frequently dismiss claims that are out of time. So it's imperative to move quickly and immediately. And arguably, if you're going to do it pro se, my recommendation is to file immediately and amend later. Under Rule 15, courts are generally required to grant liberal requests to amend your complaint over time. You need to get something filed immediately, and then if you need to amend and beef it up later, do it after it's been filed. But don't miss that deadline. That deadline is absolutely imperative that it must be satisfied. Otherwise, your claim could be barred permanently, absent an exception I just talked about, which is rarely utilized and rarely enforced. You have to make sure a summons is drafted and issued. You can also see if the defendant will waive service of summons. You have to utilize a process server, basically somebody who's going to go knock on the door and leave the documentation and have them officially served, stamped, and returned back to the court. Once that happens, then the defendant will have a certain time frame to respond. Generally, in civil litigation, it's 20 days in Texas. If it's a federal government entity, the time is extended out much further. You might want to try to be in contact before the lawsuit's even filed to see if a pre-complaint disposition can be negotiated, meaning before you go to the courthouse, before you spend the money on a lawsuit, can you get it resolved informally, absent litigation? Additionally, the filing fee is not applicable on USERRA claims. So under USERRA, although all the other federal courts require a $400 fee, you can get either recoupment of the money or you can get it waived entirely, but it requires jumping through some hoops, almost worth just filing the fee versus jumping through all the hoops. That being said, also, if you're poor and financially destitute, you may be able to avoid that filing fee if you can ask special permission from the court to avoid it. But you'll have to file an affidavit of financial hardship and other documentation and paperwork to justify why the filing fee shouldn't have to be paid. So then the next slide, we're going to turn it over now to my colleague, Nathan. He's going to talk to us about what is the procedural process of a federal court action on an employment claim, and what happens once the lawsuit has been filed. So we've gotten you up to, Mike talked about an overview and giving you some of the meat of the laws. I walked through some of the mechanics and the considerations of where to file, and Nathan's going to go through some of the logistics now. Nathan, take it away.
Thank you so much, Sean, and thank you so much, Mike, for handling the first few slides as well. So as Sean has mentioned, essentially after you file a complaint, you have to serve it to the defendant, usually either on a registered agent or for the government, whoever the designated representative is. But once all that is taken care of, as Sean pointed out, the defendant then has a certain number of days to essentially notice their appearance and respond to the complaint. Again, usually 20 days, but in certain cases they can request out. They can request. They can file a motion for extension of the deadline to ask for more time in order to respond. But there are two main ways that a defendant will try to respond. The first one is the most common, which is just simply filing an answer to the initial complaint. An answer is essentially the defendant noticing their position in response to the complaint, what they admit, what they deny, any affirmative defenses they would like to assert at the very beginning there. And basically just noticing, hey, obviously they're not, not unopposed to the complaint, and that they sit in opposition to some of the claims. They may still end up admitting to some of the more basic claims, like yes, this person did work for us, or yes, this person was terminated. But usually they're going to be denying pretty much everything else, including obviously the discrimination or retaliatory acts that occurred while you were employed at their place. The other way that they may respond to a complaint is motion to dismiss. Now, a motion to dismiss has to be filed, or usually has to be filed at the very beginning, especially if the basis is going to be something like failure to state a claim upon which relief can be granted. Now, motion to dismiss generally is brought in under Federal Rule of Civil Procedure 12, which has multiple different bases on that. But the most common one is 12b6. This one has to be asserted upon first appearance by defendant, not including motion for extension of time. But basically, if they file a motion to dismiss on the basis of failure to state a claim, that means that even though you may have felt that you were discriminated against, their contention is that the claims as asserted in the complaint do not constitute discrimination or retaliation as established by the statutes listed prior in this case, or in this presentation, or any other that would be applicable. This one is the most common, most so because As Sean alluded to, there are times that a defendant may just file it for the sake of filing it, just to essentially force you to have to do more work. But also on top of that too, and this is, why, attorneys can be helpful at this stage. But basically, if a complaint does not specifically draft the claims of discrimination or retaliation in such a way that it would fit the statutory elements for a case, then a judge could dismiss your case and essentially force you out of the courts. In which case, then you can try to appeal or just leave it be. But essentially, then you're going to have to go up to the Fifth Circuit or try to find some other way to pursue your case. Another common way is failure to file in a timely manner. Basically, if you don't file by the deadlines as specified earlier in this presentation, then your case could be dismissed from federal district court as well. There are two other ones that do pop up. So, for example, failure to administratively exhaust. If you file a lawsuit without going through the EEOC, for claims that otherwise would require you to go through the EEOC, then that could be a reason why it gets dismissed. In those cases, it may depend on whether or not there were deadlines you were supposed to hit prior. There are certain instances where motion to dismiss could either be motion to dismiss with prejudice, which means that it is dismissed and cannot be brought back again, those claims, or motion to dismiss without prejudice, which means like, okay, you can, this is being dismissed for now, but you can refile those claims in a certain manner. But usually that's up to the judge to determine. There's also failure to file in correct forum. So that's, that basically means that maybe you filed a case, but you're citing, like, for example, state law, or but you're filing in a federal district court, or you're filing in a state that has no connections to the case. So, for example, everything was happening in Texas, you live in Texas, the state was incorporated in Texas, but you instead decide to file in California despite no connection to that. That is a reason to potentially basically kick you out of that court, which is that you've tried filing in a different court that doesn't have any connection to it. There are instances where I once worked on a case where essentially a person was essentially so poor and had been forced to move to a different state because of very, very tragic and very clear external circumstances. They could file in that state if you are living somewhere else. But usually what will happen then is that they then still kick it over to the state where that's most applicable. And as previously mentioned before, there are arbitration clauses that you have to be aware of. Again, those are going to be likely in your employment agreement when you first start with a defendant. However, there are certain instances where arbitration clauses may not be enforced. So just to quickly kind of maybe not run down all of it, but basically give some background as to the current state of arbitration litigation. Obviously, the reason that employers want arbitration is because they tend to be a lot more friendly to employers. But there are instances where they won't be enforced. The most successful ones recently have been around the formation of the arbitration agreements. And by formation, it means like when you allegedly agreed to arbitration, was there an actual meeting of the minds where you did say, yes, I agree to arbitrate any claims after this, or were there issues with that? And some of the most common issues that can lead to an arbitration agreement no longer being enforced are, for example, if an arbitration agreement is inside a handbook that says it is not a contract, basically that the handbook itself is not a contract. But then second, there's also the arbitration agreement has a line for the employer to sign and the employer didn't sign themselves. And the third option regarding formation agreement itself says that the employer can change or get out of it at any time without prior notice. So the employer hasn't made any promise to the employee or given up anything really on their end. There are other times people will try to assert unconscionability of the arbitration agreement, which means that Essentially, you're trying to argue that the agreement is in violation of what we generally conceive as ethical or moral, that it shouldn't be enforced as purely from a sense of public policy, but those have not been particularly successful. As Sean mentioned as well, you can amend your initial complaint going forward. Obviously, there's a matter of process where you're allowed to amend at the beginning there, if there's anything you may have forgotten or need to correct, as well as also amending as a response to a motion to dismiss later on. However, if you use up matter of process or otherwise cannot use a matter of process to amend your initial complaint, you can still file a motion for leave to amend, where you basically ask the court to allow you to amend your motion. However, a defendant can oppose that, and then ultimately it's up to the judge whether or not they allow for such a motion to be granted. There's also the relation back doctrine, which again, it basically is just saying like, okay, these claims relate back to what you initially stated in your initial complaint and trying to get those in there. That also does help cover, for example, if there's an issue with the naming convention of the defendant as you list on the lawsuit, then obviously if it's kind of a very specific line of case law, but essentially just be careful whenever you are writing out the lawsuit and you're trying to name someone or name the defendant. Because if you incorrectly name the defendant that you're trying to go after, that could potentially be grounds for motion to dismiss. However, there is a lot of leeway on that, and you can still argue after the fact that, like, well, they held themselves out as this name, but even if they, even if like their name was actually something else completely different, there might be enough evidence to show that they held themselves out in that particular way to a point that they would have to be held to that name. Also, after all that, if after an answer or motion is granted, answer is filed or motion to dismiss is denied, then the court process really does truly begin. You have initial disclosures, and then you also have the pre-discovery conference with the judge once they're, and this is all after the judge is assigned, and then you have discovery and motion for summary judgment, which I'll talk about in the next slide. We can jump to that one. So just to sort of quickly run down what discovery is. So discovery, like I said, happens after either the answer from the defendant is filed or after a motion to dismiss is denied. Essentially, discovery is where you and the other party or other parties will be exchanging evidence back and forth to essentially prove your case, or for the defendant and that from their point of view to disprove your case or defend themselves against what happened. The judge will provide the rules of discovery, including deadlines, as well as also any potential limits beyond what's already given in federal rules of civil procedure. Usually the federal rules of civil procedure give limits for interrogatories and requests for admission, usually 20 to 25 about, but requests for production is usually not limited, but you definitely listen to what the judge ends up saying for that in terms of like if there's any issue. Now, an interrogatory, that is basically a question you ask the defendant to either identify or explain something, or basically try to answer a question as best they can based on what evidence they have or knowledge that they have. Requests for production, those are when you request for documents or other pieces of evidence to be produced by the defendant that the defendant has in their possession. Again, with a request for production or with any of these, the more specificity, the better. You don't have to know for a fact that they have this evidence, but at the same time, like, you have to have a general idea that not only is the evidence you have relevant to your case, but it's likely that they have something to that effect that you're requesting. And then request for admission is basically you ask them to say, admit or deny certain statements. Again, specificity is great with that, but also you can ask. It's important to make sure that you ask them to admit or deny what would seem to be the most basic assumptions of the case. Like, so for example, if you're filing a race discrimination case, you want them to admit, you want them to admit that they knew what your race was, and so you say, like, plaintiff was blank race. And that way, they establish knowledge, or at very least constructive knowledge potentially. You also have depositions. That's where you or the witness will be asked to sit and swear to and give sworn testimony on your case. Usually it's going to be 7 hours. There are certain instances where it could go longer, but you'd have to probably file a motion to compel or otherwise request that more hours be given. But essentially, you can add, usually the plaintiff will be asked in that case saying, hey, we're going to ask you to testify to everything that's happened. But also at the same time, too, you get a chance to ask certain witnesses, including also in the case that your defendant is a corporation, you can ask a corporate representative to testify as to what happened, what they saw, or testify to the general policies of the defendant. There are usually 30 days to respond to a request. Again, just look at what the judge is ordering on these, but also make sure you're checking what the request, the set of requests says for the deadline. You can always request an extension as necessary, but it would be up to the defendant to grant. Usually usually both parties are going to be fairly open to granting any extension at the beginning. But if it starts becoming clear or otherwise may seem to look like it's a request for extension to delay, then they have the right to basically say, look, either party can deny the request for extension for time. And then regarding motion to compel, you can file a motion to compel if the other side is not cooperating and not producing documents that they have, or is otherwise being uncooperative. There's also, again, all this is leading up to once the deadline for discovery has been met, then motion for summary judgment, which basically either side can move to basically say, hey, there's enough evidence here to decide that there is no genuine dispute of material fact, and that based on the evidence provided, that it can be decided by the judge on the merits of the case, pure and simple. If you're able to survive the defendant filing a motion for summary judgment, that's when you'll get to trial. You can also file an affirmative motion for summary judgment to say that the other side is unable to prove that basically the facts as laid out did not happen, and that the facts as laid out very clearly prove discrimination or retaliation. But that's also a very rare case in and of itself. But go ahead for the next slide. I'll pass it back to Mike.
Yes, and thank you everybody, for listening to everything. I am going to finish up here by talking about jury trials in Texas, which this could be a whole presentation, but I'll try to summarize as best as possible regarding jury trials in Texas and how they function and the requirements thereof, and then we'll open up for questions, and even some questions you already received. But in sum, so jury trials are trials that jury members are selected to decide the case. Before a jury trial occurs, the court will require the parties to submit certain information for the trial. That is called a pretrial submission, and the parties will have a pretrial conference. And the pretrial conference, the main purpose is to determine who will testify, what documents will be presented in front of the jury as well. And so the parties will determine, okay, we want this individual to testify, or we want this individual, and what documents they want. The pretrial conference will also discuss what evidence should be excluded from the jury to hear. Those are motions that either party could file, called motions in limine. Those are requesting that certain information or exhibits or testimony shouldn't be allowed to be heard by the jury. In addition, the parties will prepare questions and instructions for the jury. These are going to be first instructions that jury members will have as far as what the law is on the case and how the law should be applied to the case. And then the parties will even submit questions as far as what questions the jury should take back to the jury room to decide upon whether or not what the plaintiff was discriminated against. Those are questions that the parties will decide how they're particularly phrased, because how they're phrased could impact how the jury decides the case, and what questions the jury will ask or will answer. That's what the both sides are trying to decide in the pretrial submissions in the pretrial conference. The jury trial begins with jury selection or voir dire. That's how the jury members are selected. That's who's selected to serve on a jury. So when the trial begins, even before the trial begins, actually, there will be people that are summoned to the court to be selected, to potentially be selected to serve on the jury. And there's sometimes hundreds of people that are selected. That's, when you get the notice in the mail that you've been, you're summoned to go to the court to be on a jury. This is what this is, that you go into the court, go to the courtroom and you sit, and the parties, either the lawyers or the actual people that they're not represented by lawyers, will ask questions to each of the jury members. In some courts, some judges will want to ask the questions themselves, but the purpose is to determine who could serve on the jury, who is best able to serve on the jury. And that is a person that has no bias, that doesn't have any potential biases on the jury to either party. If you worked for the company that's the defendant, then you're not going to serve on the jury. If you have a particular bias towards awarding plaintiffs or employees money, and you say that, then you're probably not going to serve on the jury. If you have conflicts in your schedule, you're probably not going to serve on the jury. But the attorneys or the parties and the judge are trying to find the members who have no bias whatsoever, or the least amount of bias, so they could serve on the jury and help decide the case. During the trial, and even before and even after the trial, there still could be ongoing settlement negotiations. I've had cases that settle in the middle of trial. A party will give an opening statement, and then there will be a settlement. So just understand that there could still be settlement negotiations while trial is still ongoing. And I know we're close to time here, but I'll go through the rest of these. But opening statements. So opening statements is what begins the trial by each party. They give an overview of the case, and then an overview of what evidence you'll hear from either party, and how the juries should decide. The plaintiff, the person that's bringing the case, will provide their case first, and that means bringing up each witness they want to call and examining each witness. They'll question each witness and they'll present their case. And then for each witness, the opposing party, the defendant, will have a chance to cross-examine that witness. And then after the plaintiff's done, the defendant will go and present their witnesses. Now, after the plaintiff presents their case, the defendant will have a chance to request a judgment in their favor. These are almost never granted, but it's the defendant saying, well, the plaintiff's presented their case, judge, I don't think you could grant in their favor based on what they presented. But usually when you're in the middle of the trial, the judge will not grant that, and will then move on to the defendant to present their case. After the defendant presents their case, then you'll have closing arguments where each side will say, well, you've heard this today, based on what you heard, you should rule in my favor. And then the judge will give those instructions like I talked about, and go over the questions for the jury to deliberate. And then the jury will deliberate, perhaps just for a number of hours or perhaps days. I've had both situations happen, and then they'll come back and deliver a verdict. And depending on the verdict, you could also appeal. You could also pull the jury, meaning you could see how the jury, how each member of the jury determined, how they went. That is just a quick overview of the jury trial process. Again, could probably be a whole nother webinar. But understand that, there are different segments of the trial process. The trials could last a number of days, perhaps weeks. The point is to present all the evidence, the relevant evidence, for the jury to decide. And then as far as questions, we did receive a number of questions before the webinar, and we've gotten some even during it. I am going to uh, try to answer some of the questions. Open up to Nathan and Sean if they want to answer any. Some questions I see that I could try to answer. I see a couple questions on lawsuits against University of Texas or Texas A&M or the university system. We have and do handle cases against the University of Texas and school systems here in Texas. We have current EEOC charges against them. And you can bring claims against the University of Texas, including into federal court. Now, there are certain defenses that the Texas universities may raise regarding their ability to be sued, but they can be sued. That we have charges against them. They are subject to as defendants to these charges as well. Let's see. I see. Yeah, go ahead.
Yeah, just to further add to filing a lawsuit against higher education. You also have potentially Title IX at play as well. That is something to look into. And when I say Title IX, I'm talking about Title IX of the Civil Rights Act. So it'd be the same. It's the same act as Title VII, but it's just basically that one specifically covers sex issues. But yeah, there's also, I think, just also always be mindful of potentially if there's any sort of issue with sovereign immunity, but that's usually something that's not too much at play when it comes to employment discrimination. But just be aware of that potentially being one other hurdle to mind.
Thank you. Another question is whether we're licensed in Louisiana. I am licensed in Texas. I believe we're all just licensed in Texas, but I believe Sean may be licensed in other federal courts. Sean, I don't know if you are.
I'm licensed in Colorado, Texas, and New York federal courts. Also the Court of Claims in DC and the Court of Appeals of the Armed Forces in DC. But Louisiana, the only court I'm licensed in there is the Fifth Circuit. So that covers appeals in the states of Mississippi, Texas, and Louisiana. But we're not actually practitioners in the state of Louisiana. None of our attorneys are here. Louisiana follows Napoleonic Code and different statutory provision stuff. So you'd probably have to get a Louisiana-based civil litigator in New Orleans. I can refer you to several who are colleagues of mine who went to South Texas Law School with me. But Louisiana, we are not licensed there.
I see a question about hostile work environment, or at least like resigning, or at least proof of resignation for that. I know the question was asked in sort of the context of unemployment and proving it unemployment, but at the very least, when it comes to hostile work environment and quitting. So basically, in that scenario, it's a little different from termination because obviously it's not the employer that took the final act there. It's technically the employee who took the final act of quitting as opposed to the employer terminating. However, there are instances where quitting due to a hostile work environment can be still grounds for a adverse action, and that's called a constructive discharge. Essentially, it's a constructive discharge. The grounds for that, in summary, is that you were subject to such a severe and pervasive and/or pervasive hostile work environment that any reasonable person would have quit at the time that you did. And so what you need to do in order to prove up, or what a person needs to do in order to prove up that they were essentially forced to quit from the hostile work environment is essentially having proof of the hostile work environment in and of itself. So if you have, for example, like evidence that they were saying slurs at work because of your protected basis, or that you were being treated in such a way where it was very clear that you were being treated differently from other people. So for example, like if they were enforcing policies against you, but not other people that did not share your protected bases, that's another way of proving up a hostile work environment, as well as also disparate treatment. But essentially, you need to prove that other people were being treated, that you were being treated so much worse than other people that anyone else would have resigned in the position that you were in.
And thank you. So another question is about filing a writ of certiorari. stage of your case. If you're talking about the Supreme Court, understand that the Supreme Court doesn't take up, or the U.S. Supreme Court doesn't take up all cases on cert. It's really whether there is a dispute upon between the circuit courts on a particular issue, or if the issue is newsworthy and wide-reaching. So just understand that as far as trying to file there, you certainly can. There's certain requirements with your brief as well, but those are very difficult to have granted. So I think those are, I guess, the cons is that those are difficult to have granted in the employment context. But it is possible. I've written one to the Supreme Court. You just got to make sure you point out why the Supreme Court should hear the case. You have to point out the policy reasons even for why they should hear the case. There's another question
about. Oh, go ahead.
Go ahead.
Oh, well, so there was I saw a question about verbal agreements and the enforceability of those. To sort of speak generally at the very least, because again, I don't want, we can't really give specific ones if there is a potential case there. However, generally speaking, verbal versus written, you can still have a verbal agreement and attempt to at least have that enforced under federal law. However, those are substantially more difficult to prove and enforce because they're verbal versus with a written one, then people can at least review the writings in general. But if you have a verbal agreement, obviously, if you have the elements of it, which there was an offer, there was agreement, there was a meeting of the minds, potentially you can have that enforced, but that is very difficult. And I mean, the cost of trying to prove that up alone could be a big enough bar to potentially have to avoid trying to enforce it in the first place. So it's very difficult to prove up, but technically speaking, you can have a verbal agreement, but it's going to be very, very difficult to prove up.
I think the question, is whether or not that's covered under federal law regarding the agreements. Generally, breach of contract questions or issues are state law focused. They're not necessarily going to be under federal law. As far as how it can come up in the employment law context, as far as it being federal law, you're not necessarily going to allege a breach of contract claim. You're going to allege that, well, my employer, and I'm just thinking of an example, I was supposed to work for this long a period of time, and then my employer decided to terminate me. And you could allege that as, trying to rebut their alleged legitimate reasons for keeping you on. But generally, the breach of contract claims, the verbal agreements, the offer and acceptance, you're talking about under state law. And then as far as the hostile work environment portion, I think there's another portion of that question regarding what proof is needed to file for unemployment. The unemployment, and this presentation wasn't really about unemployment, but just to hopefully somewhat answer that question, is unemployment is really determining whether or not you are fired for gross negligence or gross misconduct or not. Generally unemployment is given to people that have been released because of business reasons. However, there's still opportunity to obtain unemployment even if you were terminated. You just have to show that your termination wasn't justifiable. It's a different analysis than actually proving that you were terminated for discriminatory reasons. And so to try to answer that as far as the hostile work environment is concerned, but you should at least tell the unemployment office that you didn't engage in any misconduct, you didn't engage in any bad performance. You did resign, but you resigned because you were facing this tougher employment situation. I think that is going to be, it may be tougher for the unemployment office to grant given that you resigned, but you could at least try that.
I saw one question about U.S. Marshals. I want to quickly address that. Although obviously, again, like I said, it's hard to tell without specific details on that. But generally speaking, with U.S. Marshals, if a U.S. Marshal is not able to properly serve the paperwork, that doesn't mean that you're out of luck necessarily. Again, I've worked on a case where the U.S. Marshal was not able to properly serve the defendant for like two different attempts, and then got them on the third one. However, usually something that it would be more helpful to you than hurtful if the reason that the U.S. Marshal failed to bring that out was essentially because not because of any issue that you did. So if for example you requested the U.S. Marshal or something like that a little late, then that might cut against you. But in instances where either U.S. Marshal was not doing their job, or that the defendant was essentially hiding or otherwise not setting themselves up in such a way to actually receive process, that could you still could potentially still be able to timely serve them within the specification and rules.
I think we covered all the questions we're able to answer. I think sometimes we get questions that are really fact specific of your particular case. And, this webinar is not meant to provide the specific legal advice in your specific case because we don't know the facts. This webinar is meant to provide guidance on the federal court process. If you are seeking questions or request consultation over your specific case, please contact us. You see our contact information on the screen, and we could have a consultation over your specific case. So it's hard to answer some of the other questions about your specific case without knowing all the facts. But do we have any other questions over the federal court employment process that we've discussed here today? We'll hold for another minute or so.
And we're happy to talk to you individually, privately, with a full confidence and privilege applied. Some of this information may require, information being discussed that's private and confidential. So it'd be best to talk to an attorney with that attorney-client privilege communication privately through a one-on-one consultation. We offer those services. Myself, Mike, and many of our other colleagues with our firm offer consultations quite often. So you can call our firm and get on our calendar.
All right, and with that, we'll wrap up today's presentation. Thank you for everyone joining. And of course, thank you, Michael, Sean, and Nathan for taking the time to present today. A recording of today's presentation will be circulated via email to all attendees later this week. Thanks again for attending, and we hope to have you join future webinars, and we hope you found today's presentation to be helpful. Have a great day. Thank you.
Thank you.